Mr Chair.
Rahui Katini.
Thank you, Mr Chair. The House will be aware that the Māori Party has serious concerns about this bill, particularly the way that mana whenua have been cut out of any decision-making. And I want to thank Mr Hawkins for bringing the House's attention to our minority report. I also want to thank him for the concern he's shown for the way that a member has not been able to attend every hearing of the Select Committee. And I think it's maybe his concern is because he doesn't realise that that member, as are all members of the Māori Party, in constant contact with mana whenua and are able to find out from them directly what their concerns are with this bill and with other areas. And perhaps it's because that party did not do that themselves while they were in government. And so we do have a serious concern about this bill, and we do have a solution. And I want to talk about our supplementary order paper to insert a new clause which gives effect to the principles of the treaty. And I remind the House that the relationship and confidence and supply agreement that we entered into with the National Party included in its introductory words, and I quote, "Both the National Party and the Māori Party will act in accordance with Te Treaty o Waitangi, the Treaty of Waitangi." This SOP is therefore in keeping with the efforts of the Māori Party to recognise the Treaty of Waitangi and specifically set out the ongoing decisions on which the Crown has an obligation to consult. The purpose of our SOP is to amend the Local Government Auckland Law Reform Bill to ensure that we do indeed make great progress in honouring the treaty. The SOP is designed to give coherence to the government's commitment to the partnership between Māori and the Crown, to give legal effect to the commitment to the principles of the treaty, to maintain Māori confidence in the Auckland area, and to accelerate progress towards social, cultural and economic development and well-being between Māori and non-Māori. We put forward this amendment as we firmly believe that a Treaty of Waitangi clause will provide a legitimate and substantive framework upon which decisions regarding Auckland will be considered. We also present this amendment in the context of the annual review of relations released in March by the Human Rights Commission. That review identified Māori representation in local government and an effective voice for Māori in the decisions of the new Auckland Council to be among the top 10 race relations priorities. Another foundation for the amendment is, of course, due recognition for the Declaration of the Rights of Indigenous Peoples. We're particularly mindful of Article 18, which sets out the aspiration that Indigenous people have the right to participate in decision-making in matters which will affect their rights through representatives chosen by themselves. The amendment is in itself explicit recognition that these issues are respectively not recognised by a Māori advisory group, and with that I agree with Mr Twyford. We're also motivated by the desire to uphold the nation's constitutional foundations, current law and the wish of the people, particularly mana whenua, for the benefit of Māori and the wider public. The final platform for this amendment being presented is to enact the intentions of the Local Government Act 2002, which sets the expectation that local authorities will foster Māori capacity to contribute to the decision-making processes of the local authority. Mr Chair, I present this SOP in the knowledge that the treaty was effectively absent from New Zealand legislation for over 135 years. In fact, it wasn't until 1975 that the treaty was put into legislation through the Treaty of Waitangi Act, which set up the Waitangi Tribunal and delegated a role to the tribunal to determine the meaning of the treaty and treaty principles. And since that time, Parliament has included treaty legislative references and provided some legislative guidance on the treaty's meaning. Our SOP today provides the key statement: this Act must be interpreted and administered so as to give effect to the principles of the Treaty of Waitangi. In doing so, we believe these provisions align with other similar legislative provisions which are often used in the statute to ensure the treaty is treated with the highest level of attention. But there's another element to the SOP which bears further discussion, and that is the wording "to give effect." For those in the House with a good knowledge of the statute, you will recall that, Mr Chair.
Rahui Katini.
Thank you, Mr Chair. You will recall that this is found in Section 4 of the Conservation Act. This Act shall so be interpreted and administered as to give effect to the principles of the Treaty of Waitangi. Mr Chair, if one was to wander through legislation, we would see a colourful menu of clauses which effectively incorporate the treaty. There's a rich archive of legislative activity in relation to the treaty which has helped to guide the appropriate interpretation of treaty clauses in legislation. We understand there is a wide spectrum of knowledge around this House about what the treaty means in practice. If there was ever an issue that the treaty principles should have applied, it would have been in this local government, the Local Government Tamaki Makaurau Reorganisation Act. The governance reorganisation of Auckland would have been an entirely appropriate mechanism to enhance treaty responsiveness. It didn't, more the shame, but that's another story. This bill, the Local Government Auckland Law Reform Bill, is a chance to set that record straight, to pursue an honourable course of treaty jurisprudence. Mr Chair, our intentions in drafting the treaty clause are to provide for the ongoing engagement of tangata whenua in the scheme and ensure that the distinct situation of iwi Māori, including rights and interests under the treaty, are fairly accommodated in implementation of the scheme. I want to return to the notion of treaty principles. In case there is any doubt, the Court of Appeal defines these principles as a relationship of a fiduciary nature that reflects a partnership imposing the duty to act reasonably, honourably and in good faith. The government should make informed decisions. The Crown should remedy past grievances. Active protection of Māori interests by the Crown. The Crown has a right to govern. Māori retain rangatiratanga over their resources and taonga and have all the rights and privileges of citizenship. And if members are still unsure, they should consult the Waitangi Tribunal, which gives further specificity to the principles as partnership, fiduciary duties, reciprocity, the cessation of Māori sovereignty in exchange for the protection of rangatiratanga, leading to the duty to act reasonably, honourably and in good faith, mutual benefit leading to the duty to act reasonably, honourably and in good faith, redress for past grievances, equal status of the treaty parties. The Crown cannot evade its obligations by conferring its authority on another body, active protection of Māori interests by the Crown, options, the principle of choice, and the courtesy of early consultation. And if that's still not enough, there's always the principles proposed by the Executive, the government's right to govern, the right of iwi to self-management of their resources, redress for past grievances, equality, all New Zealanders are equal before the law, reasonable cooperation by both parties. Mr Chair, I have gone to the trouble of spelling out these legislative references and description of the treaty principles because it appears that some members of the House are still not aware of their meaning. The truth is, Mr Chair, we've come a long way since 1878 in the Bishop Wiparata and the Bishop of Wellington, which suggested that the treaty was a simple nullity because Māori tribes were incapable of performing the duties and therefore assuming the rights of a civilised community. We have come a long way. We are in new, enlightened times, times which reflect the strength and survival of iwi who have advanced the debate so significantly about treaty rights. The Māori Party is extremely proud to have brought to this debate the crucial significance of the treaty for local government organisation and such a key issue as the Auckland law reform. The treaty clause is about recognising our founding document and recognising that the treaty is about joint responsibility and working together. The scheme also relies on regulations for much of its implementation. The treaty clause will ensure iwi and Māori are able to participate in the development of these rules. The amendments we put forward clarify how the rights and interests of iwi under the Treaty of Waitangi, Treaty o Waitangi, are to be incorporated in this legislation. They provide for consultation with iwi on matters